if his DNA had been anywhere in that room or in that house, the prosecution would be yelling from the rooftops that he's guilty. See. And when his DNA is not present at all, they're like, don't worry about it. That's not relevant. Come on. It's absolutely absurd.
Hello, and welcome back to 1 Minute Remaining. My name is Jack Lawrence, the host and creator of this show. We recently wrapped up the story of Marcellus Williams, a man sentenced to death for a murder that DNA proves he didn't commit. Yet his date, as this episode goes out, is still set for September. As always, with all of our cases, once we wrap them up, I sit down with the man they call the voice of reason, Michael Leonard from Leonard Trial Lawyers in Chicago, Illinois, to discuss the case and get his opinion as a man who spent decades as a defense attorney working in the United States. Here he is.
Hey, Jack.
How are you, mate?
How you doing, buddy?
I'm good, thank you. How was your ride?
It was fantastic. I'm kind of surprised. I'm kind of surprised to see you.
You're kind of surprised to see me. Why? Why? What's happened?
Well, I've been hearing you're going to try to be avoiding me because of our bet. And
Mate,
it's not going so well.
What are you talking about? I was about to break the sad news to you that it's not even been 30 days and we've already got over 10 people and a horse.
You got a horse listening to you?
Well, apparently...
I can make a joke about that.
Yeah. He was listening to my show and people asked him why the long face.
Are you really at the 10 to get you the victory? Are you already there?
One of my faithful listeners, Alyssa Cook, actually did a post in our Facebook group calling on everyone to come forward from Moree. And I'll be honest, I was shocked and surprised that happened.
Well, my friend, I will gladly concede. However, part two of the bet was I get to subject these people to cross-examination to see if they really watch the show, right? So we just bring one on. We pick one of them randomly and we cross-examine them to see if they're really listening.
See if they're legitimate listeners.
Well, it shows the reach of Jack. So congratulations.
No, thank you. I just got to get into America now. Let's not do the same thing with American towns, can we? Because I will definitely lose that one. That's for sure.
I think you're strong here too, my friend. So don't worry about that.
Yeah, well, we're getting there. Let's talk about the latest case. Of course, this is I think probably the most serious one that we've covered, seeing as that the gentleman that I've spoken to has been officially given his date of execution in September.
St. Louis County Prosecuting Attorney Wesley Bell has filed a motion to overturn the conviction of Marcellus Williams. Williams has been on death row for more than 20 years for the murder of Felicia Gale. She was found dead in her University City home in 1998.
It's important for us to get it right. There is evidence that the jury at the time would not have been able to see because we're talking about DNA evidence. I think it's called contact DNA, which was not
on the murder weapon, on the knife.
On the murder weapon.
Today, a man convicted of killing a former Post-Dispatch reporter back in 1998 is sentenced to die. But the attorneys fighting for his life say he's innocent, and they have proof.
Now, death penalty is obviously a controversial one. There are obviously people who are for the death penalty and believe that certain members of society who commit certain crimes deserve that ultimate penalty of sort of the eye for an eye type situation. And obviously there's many that don't. America's still one of the last countries in the so-called Western world to still have the death penalty in many states. Is the death penalty in Chicago? Do you guys have the death penalty there?
So yeah, for our state, the state of Illinois, we do not. We used to have the death penalty. And then about 15 to 20 years ago, the governor of our state, Governor Ryan, who was actually indicted and convicted in a federal criminal case, took steps to eliminate the death penalty. And so it's been abolished here in Illinois for about a good 15, 20 years.
Sure. There's obviously dangers to the death penalty when it comes to, giving people the death penalty in instances like Marcellus Williams. For me, again, it's just looking at the so-called, there is no evidence. And now there's DNA evidence showing that his DNA is not on that murder weapon. It's just, and no court's willing to look at it. I just don't get it. Anyway, your thoughts on the case?
Yeah, well, I guess there is a little hope because there's a hearing on July 2nd to determine whether the court will allow and consider this new DNA evidence. So I don't think we should be giving up yet, which is a great possibility. I think that far too often our procedures get in the way of common sense, especially with death type cases. Really overall, as you have discussed on several of your shows, the paramount consideration should be actual innocence and getting to the truth. And we set all these hurdles up for a defendant to have a claim of actual innocence considered, especially a case like Mr. Williams, where it's just crying out for a hearing on the new DNA evidence, right? And so far too often we let procedures get in the way of the common sense. And this is just an extreme and horrible example.
But I mean, even before we get to the DNA evidence, because of course that's only come in, as I think he said around 2016, around then was when the DNA evidence first sort of came forward on the murder weapon. If we go back to the original crime scene itself and the original case against him, we've got these bloody footprints. We've got hair that was found on the victim's body and near the victim. We've got fingerprints. DNA from underneath her fingernails, skin and matter that was found under her fingernails. All of these things tested. None being a match for Marcellus Williams. The fingerprints we don't know because apparently the police turned around and said they weren't good enough to make a decent match, and then they suddenly just disappeared, which is odd in itself. But nothing matched him. Nothing matched him at all. Obviously, the biggest thing against him was the items that were found in his vehicle. And that was only brought to the police's attention by his former partner, who also was sketchy in herself.
Yeah, I mean, the DNA, I just imagine for a second, if his DNA had been anywhere in that room or in that house, then the prosecution would be yelling from the rooftops that he's guilty, see? And when his DNA is not present at all on anything in a very gruesome crime scene, which created a lot of blood and DNA and forensic evidence, and then when it's completely absent, they're like, don't worry about it. That's not relevant. Come on. It's absolutely absurd,
I come back to what we seem to come back to on so many occasions with these cases is just seemingly lazy police work. There was no lead in this case whatsoever. It took the partner of the poor lady that was killed, him to come out with a $10,000 reward for then, all of a sudden these two degenerates to come out of the woodwork and say, we know who did it. But they seemingly had this sort of, treasure trove of evidence there, but they got nothing from it. And then obviously suddenly they get a lifeline because a guy who's been in prison just comes out and says, I know who did it. And they're like, great, fantastic, we'll run with that.
Yeah, well, they didn't have anything really to tie Mr. Williams to the murder. So I think it was one of those cases, you talk about pressure and publicity on a murder case. St. Louis is a very segregated, some have called a racist city, but it's certainly a very segregated city. And imagine in the part of the town in St. Louis where it's occupied by more Caucasians than African Americans, and you have two murders with similarities in a very short time. The shock and outrage that's was going through that community is probably indescribable. And so you can imagine the pressure on the police and the detectives to solve this case and these cases. It looks to me possibly part of a serial killer. So, if they get anything and they get these cooperators, so-called cooperators who are incentivized by a payment, a reward, of course you got to look and take that with great scrutiny, right? Particularly when you have a death penalty case, you should give that the greatest scrutiny. If you're going to give it the greatest punishment, you got to give it the greatest scrutiny. You got to give it all the procedural safeguards, evidentiary safeguards, and you have to make sure that the counsel is up to the challenge. I don't know about anything about the individuals who tried this case. You did point out that they're a private counsel. I don't know what their skills, credentials, and backgrounds were in death cases, but it's probably the most important time to have the most competent counsel.
That is the one thing that obviously, as we spoke about with Marcellus, is that if you're being tried for the death penalty, you don't just get a quote-unquote public defender. You're given, he got given two attorneys. But do the state specifically pick people who have experience in death penalty cases, or should they be doing that?
Well, typically, yeah. Typically, you're not allowed to even do the case. It depends on what state you're in. Every state varies. That's why for some of your listeners in Australia or other places might think our system is strange. We have 50 states and we have 50 different sets of criminal laws. And within those 50 states, we have different counties. And so everything varies, right? And so some states don't have the death penalty at all. Some states don't even provide you with appointed counsel like that. But most states that do in death penalty circumstances, they make the attorneys be death penalty qualified, meaning they have some experience and training in those types of cases. So I assume that was the case in Missouri at that time.
Let's talk about jury selection for a second, because I asked, obviously, Marcellus, I said, was this a jury of your peers? And he sort of laughed and said, absolutely not. And looking into the case during the whole jury selection, it said that the prosecution recused 6 members of the jury, and they all were African-American. Would they have been just able to strike 6 African-Americans and give no reason as to why they were doing that?
Well, here's how it works. So some of what you said is right on point. Some of it, I'll argue it's not, Jack. But the way it works overall in our system is that you have an overarching decision from the United States Supreme Court that affects all of these states, whether it's a state court or federal court, it applies everywhere. And that case is called Batson, Batson versus Kentucky, which established the rule that you can't make race-based strikes to the potential jury pool. So when jurors are coming in, and in our system, you might have a group of anywhere from 30 to, you might even have a couple hundred, depending upon the notoriety of the case, who might be potential jurors. They're questioned by the attorneys. We are allowed to strike a certain amount with no reason at all. Those are called peremptory challenges. And then we're able to strike for cause an unlimited number of people if we can show that they're biased. But where this issue of race comes in is in these peremptory challenges, where, let's say a federal court case I'm trying, we could strike 10 of them, and I don't have to provide a reason. However, if I'm challenged, if the prosecutor or the defense is challenged on a strike, they say, we think it's a violation of Batson. We think it was race-based. Then the person that struck them, usually the motion's being made against the prosecutor, they have to come forward and tell the judge and argue that there was a race-neutral reason for why they got rid of that particular juror or jurors. And so in this case, because I took a look at the appellate court opinion, the attorneys actually challenged only 3 of the strikes. They didn't challenge all 6 because there might have been legitimate reasons for 3 of the 6, but they challenged 3 and argued that the prosecutor was motivated by race in striking those 3 people. So then what happened was at trial, the prosecutors had to tell the judge, hey, here's our race-neutral reason for getting rid of these 3 African-American jurors. It was a little sketchy to me.
Was it something to do with postal service or something? I read something about postal service and I didn't understand it.
One of the jurors, they said, well, gee, Judge, we didn't get rid of him because he's black. It's because he's a postal employee. To me, without further explanation, made little sense. The other one, they said, well, Judge, it wasn't race. It was because of the earrings they were wearing. And we thought that meant the person was liberal. Again, to me, sounds kind of bogus. And then thirdly, for the other one, they said, which was very interesting, they said, the juror that we struck who's African-American, their demeanor is kind of like the defendant and their appearance is kind of like the defendant. To me, that's like saying it's race-based. But the court, based upon that proffer by the attorneys, accepted it and said, okay, you've offered me race-based reasons. Then the ball goes back to the defense attorney, who still gets to argue that, hey, I know they gave you what they claim to be race-based reasons, but those really are pretextual. Those are bogus reasons, Judge. Let's look at what they just said. And so ultimately the judge said, okay, I'm fine with those strikes. Those people are struck from the jury. They're not going to serve. So ultimately, Marcellus tells you that, hey, I didn't get a jury of my peers. It's totally true, but it's not exactly how it works. So really what matters in a system, at the time he was in St. Louis County in the state of Missouri, is that the system for selecting those jurors is race neutral. So unless he was able to attack the system for selecting those people, you're not guaranteed a right to, hey, since there's 40% African Americans in this community, that means on my jury panel that's seeing the case, I'm entitled to 40% African Americans. That's not how it works. It's just the process has to be race neutral. So you might get a panel one day where there's 80% African Americans to select from. There might be a panel the next day where there's only 20% to select from, right? So you can still go to trial and the court can still consider it fine and dandy, even though the racial makeup seems extremely skewed, as long as the overall process is okay to select people to serve. And then if the state can survive these challenges we just talked about, these race-based challenges at the jury selection process. So to me, the reasons given by the prosecutors seem pretty thin to get rid of those African-American jurors. And that's been an issue in our system for a long time. That's why the Supreme Court came out with that Batson case.
Let's look at something else from the case that I found interesting was, of course, they had one of their witnesses. They had three witnesses, really, three main witnesses. You know, we had the former partner, we had the guy who was in some way related to Marcellus, somewhere along the line, who'd spent time with him in prison. But then you had the third person who was sold the laptop, and he was brought to the stand to testify that, yes, Marcellus brought me the laptop in exchange for whatever it was, money, or it may have been something to do with drugs. But by the by, he brought him the laptop. The jury were not allowed to hear the part of the testimony where he actually said, well, it was actually when I was talking to Marcellus, he told me that this came from his girlfriend. He got it from his girlfriend, and that's how he came to have that laptop. Now, the judge cited hearsay and would not allow the jury to hear that part of the testimony. I thought hearsay was, well, I heard it from someone who heard it, sort of that sort of thing. It wasn't. It was directly from the guy. He said, this is what he told me. Surely that is just testimony.
Yeah, our hearsay rule is very sometimes difficult to explain to somebody else, and also sometimes seems to defy logic. But in general, hearsay refers to any out-of-court statement that's being offered at trial for the truth of what's said, okay? It's a mouthful, but in this case—
Speak English to me.
Yeah, in this case, that's the hearsay rule. That's how complicated it is just to begin with, and there's like 50 exceptions, right? But in this case, they offered the testimony of this guy that says, hey, I bought the laptop from Williams, and he was allowed to talk about some of the conversation he had with Marcellus about the purchase of the laptop. However, he was not— the defense attorneys were not allowed to introduce the rest of the conversation, because even though here's the guy saying, I bought the laptop, here's what Marcellus was saying to me, but there was another part of the conversation where Marcellus is saying, I'm selling it on behalf of my girlfriend, right? And so they allowed half the conversation, but not the rest. And weirdly, you're under the two big issues in our system. One, a defendant's statements when he's giving explanation to explain away his guilt are generally inadmissible. They won't allow them unless the defendant testifies, right? But if the defendant makes statements that implicate him in the crime, they do let those come in, even though they're not being said by the defendant. So again, it seems like one of those situations where you're putting procedure and evidentiary rules above common sense, because if this witness would have been allowed to testify to the complete conversation, he would have said that, hey, Marcellus told me he was selling it for his girlfriend, which at the time he uttered that statement, there's not really a reason for Williams to be lying about it. You know what I mean? He's not talking to law
It would be a weird
enforcement.
thing to just bring up out of nowhere. Just be, exactly. He's not talking to a cop. He's talking to just some guy he's getting the laptop, giving the laptop to.
Yeah. So the point about that is, since he doesn't really have a motive to lie to this guy at the time, it would seem that the statement that he's making is reliable and something that the jury should hear, but they weren't allowed to hear that, which I think is a crucial part of the conversation. On appeal, the attorneys argued, hey, look, not only should it not be considered hearsay, but it completes the conversation. There's a rule of evidence that allows you to put in the whole conversation when the other side tries to introduce half the conversation, which of course goes to fairness.
I would imagine if that man who was buying the laptop had turned around and said, and then Marcellus told me that he got it because he killed this woman, that would have been fine to be allowed in. Absolutely no problem.
Of course. It's such a weird rule. We
Crazy.
can't allow anything the defendant said as long as it doesn't help him.
Absolutely insane. It's a situation where I know I speak to a lot of people who have been basically given a death sentence in prison. They've been given a life without parole sentence, but at least they have time to prove their innocence. His clock is ticking, as you said. You mentioned there's a hearing coming on July 2nd, because when I spoke to Marcellus, he was still waiting on hearing about any sort of hearing that's going to be had on the DNA. So did you read something about 2nd of July? It's happening, is it?
Well, it's sort of yes, sort of no. It's a hearing on July 2nd to determine whether he'll get a hearing.
Oh, right. It's a hearing for a hearing.
Whether a court's we're going to decide whether a court can look at this DNA evidence, which is absolutely absurd. I think you got into this a little bit on the episode, but you had one governor of the state say, hey, let's appoint this board of inquiry.
What happened there?
Look into
Exactly.
the new evidence. New governor comes along and says, it's taking too long. But, even though we now have the DNA, forget about it. We don't need to consider it. I mean, how stupid is that?
Oh, it's insane. And it comes back to Missouri again, and you've again got the state's prosecutor coming out and saying this man is innocent. I think he should have his charge overturned and all the rest of it. I can't imagine how frustrating it is for him to be having to fight his own state.
Yeah, the county prosecutor in St. Louis is saying, look, we've reviewed this evidence. It's clear and convincing that he's innocent. And then you have the attorney general of the state stepping in and stepping on their toes and saying, no, we don't need to consider this new DNA evidence. I wish you could get that Missouri AG, the attorney general, on the phone to explain to you and try to justify how it could possibly be that when you have a claim of actual innocence supported by forensics, which is directly relevant to the crime, that it's his business and it makes common sense for him to step in and say, no, let's not go that way. Let's not look at that evidence. I mean, he won't come on your show.
No chance. There's absolutely no way he'll come on and justify that because there is no justifying it. Apart from, I know, no doubt you'll just get the whole thing of a jury found him guilty based on the evidence presented, and that is how our system works.
Yeah, which is really unfortunate because, I mean, you can't get evidence that's any more directly material or relevant to a case than, DNA from the fingernails of the victim. And it was a horrific crime. Let's not forget about that.
Of course, absolutely.
It couldn't be any more relevant. And every prosecutor in the country would be waving the DNA results around if it had found that Marcellus's DNA matched which was under her fingernails.
As always, a huge thank you to Michael Leonard for his time and his insights into this particular case. Now, in the interest of making sure I get this episode out to you in time, unfortunately, we still don't know at this point in time while I'm recording this whether or not Marcellus will get that hearing. However, I will have the results in our Facebook group. So make sure if you are not part of our Facebook community, just search 1 Minute Remaining on Facebook and you'll find out the results there. 1 Minute Remaining is a Mashed Pumpkin production, created, hosted and produced by Jack Lawrence. Audio and sound design by Jack Lawrence and Dom Evans of Earsay.